A University Kebangsaan Malaysia (UKM) economic scholar has suggested that the Banking and Financial Institution Act 1993 (Bafia) be amended to avoid disputes involving Islamic financing transaction being resolved based on the English common law through the civil courts. Professor Dr. Abdul Ghaffar Ismail said Islamic financial institution which offer transaction based on the Sharia will face problems should there be disputes, since all disputes involving commercial issues will be brought before the civil courts and not the Sharia courts. Prof. Ghaffar from the Faculty of Economics and Management was giving a public lecture on 27 October 2011 titled The Structure of Islamic Financial System, Supporting Infrastructure and the Effect of TEETs at the Senate Room of University Kebangsaan Malaysia. He listed out a number of such cases being brought before the civil courts to settle their disputes. They include Tinta Press Sdn Bhd vs BIMB in 1987 and Bank Islam vs Adnan Omar in 1994. The dispute will be argued according to English common law, and contracts like Mudarabah and Al-Ijarah will be forced to be interpreted according to the concept of English common laws, should there be disputes, he said. This is different in Pakistan, where its Banking Ordinance and Mudarabah 1980 provides provisions for the central bank to determine the maximum and the minimum profit margin that Islamic financial institution can use. In Iran, the Banking Act provides detailed explanation on the type of financing that can be traded by Islamic financial institution like Mudarabah, Qard al-Hasan and other contracts. Professor Ghaffar suggested that further studies be carried out to highlight the dominance of equity financing or profit sharing in the Islamic financial system. Based on the zakat calculation, either by capital method or working capital method, equity financing had become more popular among the Islamic financial system. Tax benefits has also resulted in the tendency of entrepreneurs to choose debt financing, he said.